And she has since moved her boyfriend in. This person that she claimed in her responsive declaration was only a friend and whom now she is 5 months pregnant by. So her representation to the court that this individual was just a support friend and just a good friend, no, it wasn't, which validates my client's accounting of.
Right away, the petitioner's attorney is attacking credibility. In family court, misrepresenting a relationship, especially when financial support is at issue, can seriously undermine a party's position. The argument here isn't just about a boyfriend. It's about whether one spouse is unfairly subsidizing another household.
The facts in this case. The situation mom is currently in is of her own doing because of her choices. That does not relieve her of the responsibility now to support herself and to equally support her children. She expects my client to support her, her boyfriend, and their new child. And so where is her boyfriend's obligation? That's what we have to ask. Why should my client be paying for a house to live, for him to live in rent-free? He's not paying rent. And my client is not only the out spouse, but the expectations that she places on him in the text messages are untenable and unfair. She demands money. She demands gas in her car. She demands groceries. She demands diapers. He doesn't mind those things, but he is also paying for her housing. He's paying the utilities. And in fact, he believes that her boyfriend is working out of the marital home using the internet he's paying for. So my client is continuing to pay for the internet and the utilities to make sure that they're paid, and so his credit doesn't get affected, and to make sure his children are safe. But he is seriously being taken advantage of here. That being said, there is absolutely no reason she cannot be working and as the court is aware, we just agreed to a 50-50 residential schedule. So that means that there's no reason she can't be working on her off weeks from the children. I'd like to point out for the court that she did not file a proposed parenting plan. She did not file a financial declaration. We have no idea what her expenses are, what her income is, if she has any. She needs to get a job. If her boyfriend isn't working, he needs to be. If he isn't working, then he needs to. If he is working, then he needs to pay rent, thereby reducing my client's obligation. He can choose to pay rent to my client, or he can find his own place. My client is paying for everything right now and has been since this whole thing occurred, where she just picked up and left with no notice for a month and 3 weeks, and then just expects him to be out of the house, expects it to be in perfect shape, perfect condition upon her return. My client wanted me to address the flea situation and the messiness of the house. The house is not as messy as she tries to represent. And here this guy is trying to take care of these kids and take care of kittens that she initially brought in. She decided to foster a bunch of flea-ridden kittens, and she brought them in the house. The flea issue started because of her. And then she tried to blame it on him, and now she's trying to use this declaration and this court process to say that it's him, it's his fault, it's his neglect, which is not the case. She also made some serious allegations about sexual assault, and then talked to my client subsequently, wherein she informed him that, well, the last time they were together, she just didn't want to. Never once did she say no. Never once did she ask him to stop. She never yelled, she never screamed, she never cried, she never called the police, she never sought a restraining order. Even now, in response to our motion, she's not even seeking any kind of protection order or restraining order against my client. She has no fear. You can't consent to something and then turn around and claim it to be an assault just because it wasn't something you wanted at the time. If you didn't want it at the time, you need to speak up. You need to fight back. She didn't. So she can't.
This hearing was originally meant to consider treatment in lieu of conviction, a chance to avoid a criminal record through compliance and rehabilitation. But repeated positive drug tests and failure to report to probation immediately put that opportunity in jeopardy.
Come now to the court and say that my client is an abuser and that he sexually assaulted her. Not to mention the fact that it was not in the middle of a fight. It did not occur out of rage or extreme emotions. It just occurred. They're a married couple. As to requests for her spousal support, she makes no specific requests. She provides no financial documents. We have no idea what the status is of her boyfriend. And she is simply claiming that because they were married and during the marriage, she got to be the stay-at-home mom, she should continue to live that life of luxury just after it was her decision to end the marriage, and not have to support herself or equally support the children. So we are asking that our motion be granted, Your Honor.
Right. Ms. Lowe, I have also received your response. I did not receive a proposed parenting plan from you, but I have received your response to the petitioner's proposed parenting plan. What would you like the court to know?
Well, Your Honor, there's many discrepancies in the petitioner's responses. I would just like the court to know that we had a mutual agreement when I wanted to get divorced that he would move out of the house. There was abuse in the relationship. That's why I left the home, marital home, during the time so that he could move out and it was safe. So when I returned, I have text messages showing that he knew I was at the airport. I was on my way home. He was preparing one of the vehicles for me. And originally he had said I could live in the marital home for a year. And then after I got back, everything changed. I am also 2 months pregnant, not 5 months pregnant. In regards to the sexual assault, I did cry. I did say no. I don't feel like it's necessarily appropriate for court, especially with me with no counsel, but I can't afford counsel at this time. I've done everything in my ability so far of filing TANF and filing for child support. I have thrown out many suggestions to the petitioner, such as splitting the mortgage on the marital home or him not paying the mortgage at all and me just continuing to raise the children in the marital home. I've been a stay-at-home mom since the birth of both of our children. So for those reasons, that's why I asked to stay. And that was our agreement. And he was moved out when I came back. So, I'm sorry, Your Honor.
And you, there's another adult living in the house with you at this time?
There is. I don't receive any support through the state for my other child that lives in the home who's 10 from a previous marriage, relationship. And I don't receive any kind of support for my significant other, who I am pregnant with right now.
And is your significant other who's living in the marital house with you paying any of the expenses for the home?
No, Your Honor, but I have offered to start paying expenses in the home. I've never asked the petitioner to pay the mortgage. It was his conclusion that he was going to keep doing it. He said he didn't want the power to go out on the children. But my only request was to stay in the marital home and raise my children. I'm very flexible and everything else. But because this is a first hearing, we haven't gotten that far, and I can't afford counsel at this time. So I'm just kind of doing what I'm able to.
The period of time that you left Washington was about a month and a half, is that right?
Yes, Your Honor.
And the children stayed in the home with Mr. Lowe?
Yes, Your Honor.
Okay. So what I'm going to do, going through the petitioner's proposed temporary parenting plan, give you my ruling, and then Ms. Petrie, if you would be so kind as to make any changes per my order. I'll open it up for questions too. Jump in if anyone has questions as I go through this. So number one, in general, I'll adopt the petitioner's proposed plan with some changes. After review of the record, while I do think there is some evidence of probably more like 3B problems on mother's part, I am going to reserve for now on 3A and B limiting factors. We'll reserve those for the final order. Decision making at this time, for school, educational, healthcare will be joint. I will adopt dispute resolution and custodian section 6 and 7 as written. The parenting time schedule, I will adopt with the oral agreement that the parties have made here on the record today. That will include numbers 9 and 10 for summer schedule and holiday schedule. I don't see it directly in here, but I am going to order that Mr. Lowe remain in the marital home at this time. Do not believe it's appropriate for this court to order that Mr. Lowe pay expenses of this home while a new significant other is in the home. I also don't believe, without further investigation, that it's appropriate that the children at this time be expected to reside with a significant other that the court knows nothing about. So Mr. Lowe is to return to the home. Ms. Lowe is to vacate.
This is the turning point. When a defendant repeatedly interrupts and defies direct courtroom commands, a judge can impose immediate contempt sanctions. Contempt isn't about the original charge. It's about maintaining order and authority in the courtroom.
Mr. Lowe will be responsible for payment of the, and I believe you had that listed in your original motion, all of the expenses related to the home. Yes, which includes the mortgage, utilities, insurance, property taxes, vehicle. All of that will be the responsibility of petitioner. As I understand it, this is a 5-year marriage. I'm not ordering support at this time. I'm not ordering any sort of alimony or marital payments to Ms. Lowe at this time in a temporary order. I will adopt 11, 12, 13, 14 as proposed by petitioner. I'm going over to the temporary family law order that petitioner proposed. I'm just looking through to see, I believe it's mostly in accordance with exactly what I've already ruled on today. So I will adopt in its entirety then the temporary family law order, which does require that the petitioner or allow the petitioner to return to the home and stay in the family home. Respondent must move out of the family home within 30 days of today's date.